Yes.
My lord, I am for the petition, my lord. Due to my personal constraints, I could not prepare the reply.
Which matter?
I don't know.
This has not been called.
My lord,
Sorry, mention for application, new application. But may I be permitted to?
If there is a date given already by the department, let it come on the date.
But may I be take the leave of your lordship my lord, in two matters. Where my lord, the issue is same my lord, shortfall of service which has been held in Tapan Kumar Mondal's judgment affirmed by the Supreme Court. Now the department is passing the same order. My lord, we have approached the tribunal. There is no judge. Now the date has been fixed in June 2026. My lord, if your lordship kindly, my lord, person is not getting pension for last 3-4 years.
Mention after the new holiday. You mention after the holiday. It can't be done this side anyway in 2 weeks. You
But
mention in
it is
January.
only 1 minute time. The issue is settled by your lordship, but
Mention.
by the Honorable Supreme Court.
We are telling you mention in January. We'll take it.
January.
Yes.
For last 4 years, I'm not getting.
That's
pension.
why hardly 2-3 weeks you can easily wait. Yes.
Sir, may I take your lordship's kind leave my lord, to file it?
You can file it. You need the leave to file. Why?
My lord, otherwise, it will take at least 4-5 days to get the number.
What is the system? Otherwise, how it is done? I would like to know.
My lord, the new system is the moment my lord, I file it in the department, my lord, they check all the files, all the my lord, annexure and my lord, all the details. Thereafter, my lord, they give us a F number, a temporary number. Thereafter, my lord, after completion of all the scrutiny, they gives us my lord, the permanent number, WPST number. So it takes.
Why it should not be scrutinized? Why should it not be scrutinized?
Well, the department the filing section.
So why it should not be scrutinized?
It should be. For this reason, my lord, it takes at least 4-5 days time to.
So if you file it here, how it will be scrutinized?
No, they will give me leave to file it in the appear this matter on a particular date. The department will scrutinize and make the process faster.
Department. File it. We are asking you to mention in January. Why are you filing it right now?
5-6 days it will take.
Please.
Lordship,
Yes.
may I be allowed to mention one matter? I have mentioned the matter on earlier occasion, Your Lordship. Your Lordship was pleased to allow the same. So, Your Lordship, the WPST was dismissed by Your Lordship and Honorable Justice, Your Lordship, Supritam Bhattacharya in Your Lordship, December 2024. Now, Your Lordship, there are some Your Lordship documents which was not considered, and later Your Lordship, the petition also found.
You have filed a review.
Yes, so
When
I have
the
already.
bench is available. It will be listed. We have already told you. Please wait. Yes.
Yes.
With leave of my Lord Justice Biswas, may I be permitted to mention one matter, my Lord? The matter was CAB by your Lordships, and one judgment we cited before your Lordship that was not in the file. So your Lordship give a date, and the matter come on the very same date. But due to some difficulties, the matter couldn't be heard, and the judgment couldn't be submitted before your Lordships. And the matter supposed to come on 11th of November 2024. So
24.
25, sorry. It's my mistake. 2025. So if
Give it, we will see. You want that it should be listed.
yes,
The problem is that bench when that
bench is
so
not.
we'll see. Just give the number. We'll
Just
try
give-
to.
What?
May I have your lordship kindly to mention a restoration application?
Give.
Yes, I'm handing over the statement. This matter was appearing in your lordship list only because of the fact your lordship has released this matter only because of the fact this matter was dismissed for default by my lord Justice Devanshu Bosak, my lord. Your lordship said whether show me the circular. My lord, it is in the my lord monthly list. Circular is there. The bench which hears the determination, they can hear the.
When the bench is available, even then.
Even then, it is a circular of 2007, my lord.
Show us, please.
My lord. This one. From 2007, it is going on, my lord. From that day, my lord, I'm in search of this circular. When the,
He asked you,
yes, my lord. And on that day, my lord, I
in
find
High Court, this does not happen. If it is dismissed by a particular bench, it will be restored by that bench only. Unless it is not available, then another bench is assigned the matter of one of the judges still available. If he is in the DB, it will be placed before him. Otherwise, it is not done. If you have a notice, you take it.
but I'm handing over the slip right now, my lord.
It could be just a contempt application. The bench will, the bench is available. With restoration. That should be heard by the bar, by the said bench.
Item number 1.
Lord, item number 1, I am appearing for the petitioner, my lord. My lord, due to my personal reasons, my lord, I could not prepare the affidavit in reply, my lord. I am praying for a week's adjournment. But last week, my lord, I was.
Is there any interim order?
No.
Appointment and corporation.
Huh?
Compassionate.
Corporation now.
Twenty-third. 23rd. Monday, Tuesday. The days. Item number 2.
Millard, I appear for the petitioner, Millard. Affidavits exchange. But Millard, the learned advocate for the state, Millard, Bishwabrata Bosu Mallik was there. Millard, by reason of sudden change, Millard, and Biman Haldar has been, he's a GP office informed us that Mr. Biman Haldar is there. And Mr. Biman Haldar yesterday requested my junior, Millard, that on account of his personal difficulty, he is absent from the court today. Millard, if your lordship, but pleadings are complete, Millard, in all respect.
So now who will appear? What is his name?
Now, Millard,
Can
Mr.
we
Biman
record
Haldar. Advocate on record is the same. And the GP office said whatever the communication that is required to be made for this particular proceedings, we have to deal with him. So yesterday he called my junior saying, Millard, Mr. Biman Haldar.
Iman Haldar.
Haldar. Millard, he is the advocate on record. He
We are informed by.
Mr. Biman
We don't want to take up the short matters.
I'm always engaged in short matters.
That's why we are saying we don't want to take up the short matter.
13th January.
13th January.
Item number 3.
Item number 3, my lord, I am appearing for the petitioner. My lord, on the earlier occasion, your lordship pleased to direct the state respondent to file a compilation consisting with the various notification which shows that there is a mandatory requirement for getting the treatment which will be occurred out of the state, my lord, but and with the prior service, my lord. But no,
Not here.
yes, no such service has yet been done.
Maybe it is in the process, just not today. We are not urgent. Because this is reimbursement matter.
Item number 4.
Okay. My lord, there is a direction upon me, lordship, to file a supplementary affidavit, as your lordship direct me to annex the original application of the London State Administrative Tribunal, my lord. This is the
And who is appearing for the other side?
well, on the last occasion also he didn't appear, my lord. Well, may I submit, my lord, the supplementary affidavit?
Yes, yes, please. Supplementary affidavit is taken on record. Yes, what is the issue? Let us.
My lord, the issue is regarding the compassionate appointment, my lord. My lord, the issue is regarding the compassionate appointment, and the learned tribunal lordship, they straightway rejected my claim because this is the observation of the learned tribunal that the petitioner applied after several years of this notification. Since
What is the date of demise?
lordship, the date is demise, lordship, 22nd October 1993.
And
And
you
lord,
are,
initially the mother applied.
you are the son.
Well, I am the son.
Initially, mother applied.
My lord, initially mother applied lordship 31st March 1994.
Yes.
But when lordship, I was 11 years.
Then
Thereafter, lordship, when I attained the majority lordship, I immediately applied for my compassionate appointment. But in the meantime, lordship,
2001.
my lord, I applied 2000. My 2000, my lord, 18th July 2000.
How can you said that you were 11 in 94, then you would become major in 2001 if we are.
No, my lord, when my father died, that time, lordship, I was 11 years.
Oh, at that time you were.
Well, that time I was 11 years, my
I
lord.
thought when your mother was.
No, my lord, no, my lord. That time I was 11 years.
So your mother applied after how many months?
My lord, after 1994,
5 months.
after 5 months, my lord.
And he attained majority on which date?
My lord, he attained the majority.
January date.
My lord, maybe 18th July 2000.
2000.
2000.
And when thereafter what happened?
My lord, thereafter, my lord, they three committee members was formed. One member, and that members, my lord, if your lordship kindly allow me, that 3 members inquiry committee as per the government order, and they said to make an inquiry and submit report published in the year 2006. And in that report, my lord, my mother's name has been in the list. My mother's name was there.
Yes. So she was found eligible.
My lord, in the year 2006, my mother's age is more than 50, my lord. Thereafter, she, my lord, through an affidavit and also made an application that instead of me, kindly allow my son.
So where is this 2006 notification?
2006.
Declaring her as eligible or selected. Where is that? Which?
My lord, my lord, before that, if your lordship kindly come, before that, if your lordship kindly come, page 65, my lord.
Yes. Of 65 of?
Of my writ petition, my lord.
Yes. Yes, what do you want to show?
My lord, in this case, in returning here with the document submitted by memo under reference, you are instructed to follow, my lord, that has been their internal communication regarding the guidelines for dealing with the employment on compassionate ground, my lord. My lord, thereafter, the next.
Can you show us the 2006 notification where your mother was declared?
2006. 2006. My lord, 2006 notification, my lord, has not been annexed, but my lord, other part has been mentioned in the my annexures, my lord.
ওই তো 1809 হ্যাঁ দাঁড়া এফএম এ 1 অফ 2018
Your first application is annexure E.
My petitioner's application.
Unless you can show something prior to that.
My lord, page 43. My lord, the translated part will be annexed in my supplementary affidavit.
43
Hello.
of the supplementary.
Oh, my lord, for my writ petition, my lord.
No, we said that your first application is 15/2/2000. Annexure E.
18th July 2000, my lord.
No, page 29 of the writ petition, annexure E.
My lord, my lord, annexed at P6, page 43 of my writ petition. Well, all these are in Bengali, my lord, but I have translated it.
All this is not in Bengali. You are giving a wrong page number.
My lord, page
Don't
40
bother to check things. There is no responsibility by the lawyers. Very unfortunate situation. Page 43 is this.
my lord, in my writ, my lord, this is my lord, supplementary affidavit, my lord.
First you refer to one and then you jump to the other. So this is of
My lord,
which date?
my lord,
18/7,
July 2000,
18/7/2000.
7/2000, my lord.
This is your first application.
My lord, this is my first application when I attained the age of majority.
Now you come to your OA. Yes, 18/7. So it is annexure E. Stop. You have not annexed it with your OA.
My lord, I annexed in my supplementary affidavit, my lord.
That is why we are looking at your OA. Where is it in your OA? There.
My lord, in my way, lordship, the pleadings in page 5. Pleadings in page 5.
Madam, it says letter E.
My letter E.
Where is that? E. You look at what you have annexed in E at page 29.
Wait, wait.
Wasteful exercise of filing a supplementary which is not in order.
My lord, this is the entire way. My lord,
This is the entire OA. So this is how it has been filed. Cannot be. Either before filing the supplementary, they have not bothered to check, or in the tribunal, they have filed it like this without the.
my lord, I entirely annexed what they have filed in the supplementary affidavit.
You may have, but you see what you have stated in para 6.6. 18/7/2000 and formal education certificate of 15/2/2000. But at page annexure E, it is a different document.
My lord, that is page 22 in the original application, my lord, letter E, page 22. Page 22.
There is no 22 in this supplementary. After 21, there is 23. You don't bother to check. That is the whole problem. Nobody has the time to look at what is being filed. Just put it in the court somehow. Waste of time and waste of resources both. And a futile exercise. See. Difficult to read.
My writ petition, my lord, I have
What,
annexed.
madam, just show her. What is just see what you are doing. What do you expect? Keep it impossible to read. What do you expect?
দেখেছো কপিটা পড়া যাচ্ছে না।
Nothing is in order, nothing is legible, and you are arguing.
But My lord, I know, my lord, I am.
Please let him read. I can't understand. You're not given a forget about translation. You're not given a legible copy of the original document. What about translation? What to talk of translation? It is only for filing, not for the court's understanding.
He said that my mother was working in such and such place. I am his adopted son. If the job is not given to my mother, it may be given to me. Date it is July 2000.
Yes, 18 July 2000. We have seen it. So, what is your case? Please proceed.
My lord, after that, my lord, if your lordship kindly come, page 47
47 of
of my
of the writ petition or
my
the
operating petition.
so you have submitted a format also.
Format also. My lord, thereafter, my lord, that is also the lordship, they cite title of
But-
this application.
What is the date of submission of this format? Yes.
My lord, this page 58, if your lordship kindly come, page 58, that is the forwarding letter that lordship sent in 5th January 2024 with this application form, my lord, regarding the employment. Page 58.
No, this is of 5th January 24.
My lord.
So you submitted the form in 24.
My lord, before that lordship I have sent, but this they are rejected on these issues, my lord.
Whatever it is, so there is no date of the form.
Well, that is
form.
the contention of the my lord, learned tribunal, my lord, because this is the forwarding date. With the forwarding letter, my lord, I have submitted this application, the 5th January.
5th January 24.
24.
Yes. So prior to this, there is no submission of application form.
My lord, prior to that, lordship, I have filed several applications, my lord.
Just show one. When did you file the application form? After 18/7/2000, when did you file the application form? Forget about several, just show one.
My lord, in 2000, after that, my application, my lord, that is the 2024. That is the application, my lord, along with this forwarding letter.
So the first time, yes. Now what is your case?
My lord, after that, if your lordship then come to page 65, that they mention, that is their observation, my lord.
No, for a death which occurred in 93, format submitted in June 24 is required to be looked into.
No, my lord. In the meantime, lordship, my mother made several applications and my mother's name has been reflected in their list.
Yeah.
My lordship kindly come.
What did she do after she was called for the process?
Not even called, my lord. Not even called. My lord, page 45 of my writ petition.
She was not called.
No, my lord.
Where have you said in the OA? Come to the OA, say. Show us the averment that she was never, no action was taken and forever.
My lord, page my lord, page 7, internal page, my lord.
Yes.
Page
Page?
page 14 of my supplementary affidavit.
Yes. Yes.
The applicant further made an application in the form of a reminder for his compassionate.
Madam, you are reading, everything is starting from 24. We are saying from 93 to 24. For the more than 20 years, 21 years.
Name, my mother's name has been reflected in the letter that has been annexed in my original application.
So therefore, whether that's why we asked you for a death which occurred in 93, based on an application of 24, they are required to proceed for consideration.
All the applicants are requested with their original documents, supported with their applications. That is true.
What the tribunal has done, let us see. Yes. And there is nothing in your OA why your mother didn't participate in the process when she was called to.
My lord, she never called, my lord. She never called, my lord. My lord, their name, her name only reflected in the list, my lord.
Come to page 28 of your supplementary affidavit. All the candidates are requested.
My lord, this is lordship. In the name, his lordship. That is their only paper in pen and paper, my lord. She never called, my lord. And my lord,
Madam, this is annexed by you.
my lord.
That you were called on in 2006. There is no averment in the OA that you went on this appointed date and nothing happened. So how are you making these submissions?
My lord,
Please show from your OA. This is issue of fact. Don't make a submission. There is a document dated 2011-2006, which is requiring you to come with all documents. What happened? What have you said in the OA about this?
my lord, in My lord, that has not been reflected in the,
Then enough.
that is not been reflected.
Anything else?
My lord, my humble submissions, lordship. On the similar situations, persons have already been appointed on the same situation, my lord. If your lordship in page 29, the lordship now,
Page 29.
page, my lord.
First have a look, then tell us. Everything is, your file is totally messed up. Not legible, not paginated, nothing, no translation.
Page, '28, my lord, page 28
Of
of my supplementary affidavit. That the lordship now has been mentioned just now. My lord, this page 19, serial number 19, my lord,
yes.
got the appointment.
Why not? She must have responded to this.
My
She
lord,
must have responded to this. You have not responded. What can happen?
my lord,
You are in the same list. You are above her.
I am the same list.
You are above her.
My lord,
You have not said that you went after this. Where is the question?
that has not been lordship, reflected in the way, my lord.
Sorry,
My lord,
that is an issue of fact. You cannot submit unless it is
no, my lord,
stated.
that I cannot go beyond
Don't say anything.
original application. That I cannot go.
That fact that you have omitted to say anything about it means that you did not respond to this. You have annexed this. They are asking you to come with all the documents in 2006, and another person, you are admitting that from this list she has been appointed. So
My lord, may I come back with,
sorry,
if
enough.
my lord, but my lord, give a last chance, my lord. My lord, give a last chance.
Heard the learned advocate.
5th January, my lord.
Oh, 5/1. 5/1/2024.
Item number 5.
You are filing it. On time.
The petitioner. My lord, kindly see your lordship's order. First, 14th, my lord, the 22nd September. Your lordships was provided them 4 weeks time. Subsequently, on 14th November 2025, your lordships was provided them 2 weeks time. They have not filed. My lord, today, my lord, when the matter is being taken up, my lord, because your lordship's order was that liberty was given to the petitioner to file a reply. But I am preventing not to file any reply. Today, my lord, just now he is trying to hand over. I have sent the letter that please supply me a copy. No copy was served.
What do you want, sir? You need time for reply.
No, I am not on that. I am.
You want to file a reply or you don't want to file a
No, I want to file a reply, but this is the practice, my lord.
What do you want? Therefore, we are asking you, should we not take the counter, the
No,
affidavit
definitely,
in opposition?
Definitely, I shall file a reply, but the time is.
Like this unnecessary submission, how much time for reply?
But I will take only 1 week.
All right, as paid by petitioners council, 1 week is allowed for filing a reply.
For 2 weeks. Days.
Item number 6.
6, my lord, I'm for the petition. I'm being led by.
6. Proposition is prepared and it is sent to the department, my lord. But I asked one.
My lord, 1 week, my lord. My lord, let me file it today, my lord. I shall.
He is saying it is in the, it has been sent, so you will not be able to file today. File it within a week. The-
No.
Yes, the state was also required to file. Otherwise, this order will become meaningless if they don't file within a week.
That told us that 1 week time.
1 week. for both respondents.
My lord, the returnable date.
Commission and state both. First, second week, second week, after holiday.
After holidays. Virat. 19th,
Don't you have বললো তো?
second week after holidays. 19th January দিয়ে বলছে 19th January.
Affidavit to be filed within a week, matter to be listed after second.
19 one. বলবো next.
Yeah.
Item number 7.
I'm for the.
No, this is my.
An affidavit in opposition is filed today. Stop.
Instead of 19th January, can it be on 20th January?
Huh?
Instead of 19th January, can it be on 20th January?
19th, otherwise it will be on. Copy was handed over 2 days.
No, 19th.
27.
Why 19th? This is. Oh. Then 20th can come. Oh. Is 20 all right with you? No.
20th all right.
20.
Item number 6, my lord, can you take instead of the vacation, my lord? Take only 3 days to file or
Cannot be done. Not possible. Yes.
Item number 8.
The petition on lordship, I am praying for not today, lordship.
Hmm?
I am praying for not today, lordship.
All right, not. Not.
Item number 9.
Board is functioning. Board is functioning. What? Next. Huh? এমন ম্যাটার দেয় মিশা হয় না
Item number 10.
পরে দাও
This of Friday.
None appears.
That is called. Dos.
Those.
Item number 11.
Same order.
Item number 12.
All once again.
Item number 12.
Same order.
Item number 13.
My lord, the writ petitioner was dismissed only on the ground of limitation, my lord.
Limitation.
Limitation.
How limitation will apply to a writ?
My lord, just just reading the relevant quality portion, my lord, of the order, my lord.
Must be some.
Page 3 of the order, my lord, last page, my lord. In view of the above, the instant lit petition being WP number such and such stand dismissed on the grounds inordinate and unexplained delay on the part of the petitioner to approach the court. So it has not yet been decided on merit, my lord. My lord, only respectable submission, my lord. Learned single judge overlooked the important point in the service jurisprudence, my lord. May I read, my lord?
Just give us a minute, please. Yes.
My lord, just my only respectful submission over only one issue, my lord. Page 6, my lord. May I read, my lord? Maintainability of writ petition under service jurisprudence, even when the respondent disclosed the admitted fact of their communication dated 5/3/19. 5/3/19, I have received one communication, though the matter was dispute and started from the year 1999, but it was continuing, that is continuing cause of action under service jurisprudence. But even in that matter, I received on 15/3/2009, my application was dismissed on the subject matter dispute in the writ petition whereby and whereunder the compliance dated 5/2/2019. First I have received one application from the respondent, that is 29/1/19, and I complied the letter on 5th February 2019, and it was dismissed in the March. So actually these matter overlooked probably, my lord. There is no question of limitation, my lord.
What happened in 2019? It is not clear.
2000, my lord.
2019, what happened?
2000, my lord. Actually, at that time he was in the service, petitioner, and
No, he was not in
deprived
service.
from the rightful increment, my lord.
In 2019, what is it that you claim gives you a cause of action? What happened in 2019? You see your ground number 3. You please see your ground number 3. What is it that you are referring to? We are unable to understand.
I am coming, my lord. Ground number 5, my lord.
No, sir, 3, please.
Page 5. 3. For that, the honorable judge has failed to appreciate that the communication dated 29/1/2019 of the respondent and reply thereto on 5th February 2019 of the
What are
applicant
these two
petitioner.
documents? What are these two documents? What happened on 29/1 and 5/2?
This document, my lord.
Yes.
That's I am submitting, my lord. Actually, this petition was filed 2009. At that time, the Calcutta was under full corona, my lord. So everything, all records were all was submitted, my lord. But unfortunately, this is not yet traceable, my lord. This has become the problem, my lord. Otherwise, the issue is the single one, my lord. Otherwise,
Oh. 99. Was he in service in 2019? Therefore, how can he get an increment in 19? He cannot.
No, at the time of the service, my lord.
His increment was 1993. In 2007, he did not challenge that his date of increment. Now, after retirement, he has retired in 2007. In 2019, he filed a petition challenging that my increment is due in March, but you have given effect of April. Since 2019-93. That's why trial judge stated that inordinate delay and without explaining any delay, reason of delay. Yes.
So it is not a claim for increment. It is shifting of the date of annual increment.
Only my lord, cause of action.
Date of the annual increment.
Shifting date of annual increment.
Only cause of action is the issue, my lord. Once I have been asked to submit some document, I have submitted the document in the year 2009, and that was rejected. So is it not the cause of action, my lord?
No, that's not the point. You have raised.
I have no right to move the matter before
Where
the
is
court.
that document? Again, we are asking.
That is the question, my lord. That document I can able to collect, my lord. But that petition is not traceable, my lord. So I seek lordship's advice. I shall be very grateful to you.
You are expecting some monetary benefit.
My lord.
You are expecting some monetary benefit.
Monetary benefit.
And you are not, and you are not keeping the records on basis of which you want the monetary benefit. So how can you get it?
No, I have not misplaced, my lord. It was submitted court, my lord. But it is
very well.
It is
So
not,
file a suit.
traceable, my lord. That has become the problem. Otherwise, no.
That is why we are saying for your own benefit that document is required. You don't have it. And they are saying now we cannot trace it because it is of 1993. Then what do you expect?
Actually,
how can this is a preposterous situation? The person who is to get the relief, he doesn't have the document.
My lord,
He
those
says
pa-
now misplaced,
my lord,
and they are
those-
supposed to give.
Those papers may be available with the client, my lord, but only the writ petition.
If you have any document,
What is my?
if you have,
Let the matter be decided.
no,
Let the decided on merit, my lord.
no, sir. If you have any document, contemporaneous document, which you can show them, you may do so, otherwise nothing.
Document relating to the 2009, I will be able to.
We don't know whether that 2009 will suffice. You will have to show them something of 93, 94 of that time. If you can show them.
Then I have to take the instruction, my lord.
No, we are not keeping it pending. We are giving you liberty. If you have any document of that time, you can approach them. For shifting of the date.
Application both, my lord. Actually, before the honorable division, my lord, issue for decision only whether it is barred by limitation or not. That particular document, probably, my lord, I'll be able to collect it from the client.
So we have said if you have it, you go and get your. You will get your.
So in that case, I have to approach the single bench.
Yes, you have. No, you have to approach the authority.
Well, document, that is not the problem. The documents everything with the authority, my lord. Only question is the limitation, my lord. Until and unless the
Item number 15.
my lord, that court will not be able to interfere in the merit.
Item number 15.
My lord.
14. Item number 14. 14.
42.
Item number 14.
Same order. No, no.
Item number 15.
Came out. Last date is different, 28.
Item 16.
Still pending. Came out.
Item 17.
Right, it's okay.
Item 18.
Copy paste.
Item 19.
On behalf of the respondent, my legal aid has given me this instruction. Kindly have a look. Pardon me, only one copy is there, my lord. Kindly have a look, my lord, to this. Last, my lord, yesterday after 4 o'clock, I got this instruction.
What's up, What's up,
They have not served copy to the client, my lord. Client is not aware of the fact that appeal has been filed before this court. Client is residing at Raniganj, my lord.
They are representing the client, my lord. They had represented the client, my lord, in the trial court, my lord.
Trial court, but now we have filed an appeal. They are not aware. We have filed appeal in 2020.
How you are representing them?
Now,
Representing
yesterday
them, no.
got the letter.
But they are representing them, my lord.
No, my lord. Yesterday
Suppose,
got
my
the
lord,
letter.
if I represent a
What are you doing? We are trying to read something and you are amongst yourselves, you are arguing. What is this?
Sorry.
You are appearing through the legal aid.
Yes, my lord.
Then why? What do you want us to? What are you trying to say? We don't understand.
Client has not approached to the legal aid. If the lordship direct, then legal aid will arrange an advocate, or he will legal aid will ask me to appear before your lordship.
No, this has been written to you.
Written to
This
me
is for you
take
to
the
do.
instruction from the client and to whether
This is between you and your client. Why do you want to show it to the court? This is a privileged thing. Why should we get into that?
the notice, no copy was served to the client, my lord. They are not aware that mat has been appeal has been filed
You appeared in the writ proceeding.
in recruiters act. Yes, my lord.
So what is the document that has to be served on you? The memorandum? He will give you the memorandum. You take it.
And my lord, in that case,
Section
my
5
lord,
memorandum
I have to talk with the client.
You have to, yes, that we understand. But what are we to
Yes,
do in this?
grant me some time.
So you get a copy and we will take it up. Give her copy.
But I have given copy, my lord. If you
Sir,
will not
give her what is
taken
the.
up,
I give her a copy. What is this? Copy
However,
of-
there was a direction from this court, my lord, to district level legal service authority, my lord, to be engaged in this matter.
Huh?
There is a direction of this honorable court, my lord, to the district service authority, find page 86.
Page
Page 86, my lord.
in the writ proceeding.
Yes, my lord. That's why, my lord, an appeal is a continuation of proceeding, my lord. Your lordship.
So therefore, you should not give a copy of the memo and application.
But I have served to them, my lord. I have served to the legal, my lord, I have served to the legal service authority. If your lordship wants, I can again serve, no problem.
Yes, you serve it. That is what we are saying. You serve it. Let the copy of the memo.
But I said, sir,
We have given you a fortnight.
January.
Directly or
14th January.
I shall serve directly to the client or
14th January.
Oh, you give her.
You serve to the client. The client did not know whether this has been
already I
filed or
are you legal?
not to me.
I
to
did my
client.
evident service for going on it, that service has been
When you are appearing, why he should serve to the client? You have to take it. You try to contact. Let's see what happens. You give her copy.
Item 20. Appearance.
My lord, I preferred a writ petition
Yes.
with the contention that there is an unauthorized construction of G+4 building at 43 Kustia Masjid Road, yes, Tilchala. Now the writ petition was disposed of. Lordship, may kindly come to page 45. Finding. The corporation, a municipal corporation submitted a report. Lordship will find the report on page 48. And kindly see the order. No sanction. Lordship, may kindly see the order.
এটা যেহেতু ও খাতুন হবে না, একটু খাটু খাটু টাইটেল পায় দেখ না, এটাতে দেখ না, দেখ না, এটাতে দেখ না।
Yes.
The person concerned, Lordship, who has caused the unauthorized construction, he is respondent number 8. He appeared before the London single judge, Lordship, page 45. It was his duty also to produce the sanction plan to justify that the building is totally unauthorized.
In a writ proceeding.
In the writ petition. He also
In a writ proceeding.
KMC, no, there are two parts, Lordship.
The issue is whether this is to be looked into in a writ proceeding. Or is there any authority prescribed?
Authority prescribed is the.
Then why the writ proceeding, sir?
Lordship, the Kolkata Municipal Corporation.
We don't know whether it is right or wrong. Why writ proceeding? Forget about the report of the municipal
Lordship,
corporation.
writ petition is because if there is any authorized construction.
Therefore, writ petition has to be invoked. Wonderful. There is no authority under the building
We have
bylaws.
approached the municipal corporation.
Go and pursue it there.
They have not considered.
We don't know.
That is why writ petition was filed, because we
don't
have
know.
given representation.
We don't know. The
Several
representation is not invocation. You invoke the authority of whoever you want to.
We have invoked the authority, Lordship. We have
Where is
invoked
that? Show us.
Lordship.
Which document?
Lordship, we kindly come to page 30. Page 29, Lordship. I'm so sorry. T2. We have written to the municipal commissioner, to the mayor, to the director general building, the executive engineer, Borough 7, police authorities, everybody was informed.
Why police authority? What police will do?
Because there is also a provision in section KMC Act, section 401, capital A, that in the event if it is found there is unauthorized construction, police will also initiate FIR. So both the authorities we have touched. The municipal corporation to discharge their duty.
Just because someone says it is unauthorized, police will issue FIR.
Not initiate FIR.
Or after there is a finding, there the police will issue an FIR.
I'm grateful, Lordship.
Then,
but the corporation findings.
The question of issuing an FIR.
The corporation finding is there in page 48. Kindly see how they have come with the report. This is the finding.
This has been recorded by the single judge.
But that recording of, with all due respect, with all humility, Lordship.
This is not the forum. With this, we will not open this issue here.
Lordship,
Why are you shying away from the statutory remedies? You tell us that.
Lordship, kindly appreciate, Lordship.
You avail your statutory remedies. Where the question of the writ court going into this?
Lordship, there are even the Honorable Supreme Court also held.
Show us judgment. Come with, show us that the writ court will exercise jurisdiction when the statute is there for looking into the issue of an unauthorized construction.
The writ court, Lordship, is the only purpose is.
Don't go on general principles.
Actually, Lordship.
This is a matter regarding property.
Lordship.
An alleged unauthorized construction.
Lordship.
Now, in that, the writ court will interfere.
Writ court will see whether the authorities are discharging their statutory
There
obligation.
is no question. You have not invoked any statutory remedy. You have just short off letters.
We have given the representation.
You have just short off letters.
Lordship.
You have to invoke the statutory authority in accordance with the procedure prescribed in the perhaps Municipal Corporation Act would be there. We don't know the provision.
There is no such provision that I have to.
Cannot be, sir.
Lordship,
We have not seen, at least speaking for myself, I have not seen, but it cannot be.
Lordship, with deepest respect, Lordship.
We
have seen that, Lordship. We have done several cases. If there is an unauthorized construction and if I bring it to the.
You come to the writ court.
No, we'll first approach the concerned authority.
Go and approach the statutory.
Lordship, they have not acted upon.
We don't know. Where is the case number?
Lordship,
where is the case?
They have not acted upon.
Where is the case number?
If there is a case number, there has to be some action.
Yes.
They have not taken action. Inaction.
Where is the case number in which no action is being taken?
That is why writ court we have invoked, because they have failed to
Not
discharge their statutory
not with
obligation.
the handle of the writ court. You go and invoke the jurisdiction. Then we'll see whether there is action or inaction.
Lordship, just give me. Lordship, there I'll come back with one judgment.
No coming back. What is this? Nothing remains.
No, Lordship, I'll show you one.
Avail your statutory remedy.
Lordship, one separate, because the settled law, Lordship, so I was in the impression, Lordship, that.
As far as I know, or we know, the settled law is that writ court will not look into this issue of unauthorized construction.
Lordship, writ court will not look, but Lordship will also see.
Failure of the authority, failure of an authority to discharge its statutory duties will arise if you have invoked the statutory remedies, not prior thereto, and going with the order of the writ court to invoke the statute.
This act,
that we will not
this
permit.
act does not provide anything beyond that. If there is unauthorized construction and if it is shown to the statutory authorities, they are bound to act.
How it is to be shown?
Lordship, I have given the representation. With
Under which provision? Under which provision?
Lordship, I.
Under which provision, sir?
Lordship, there is no provision in the act.
Cannot be.
Lordship,
Cannot be.
Lordship, I would like to go for.
That for an unauthorized erection being done
Lordship,
within the municipal limits, you have no statutory remedy under the Calcutta Municipal Corporation Act.
Lordship, there is the order of.
There
section
must be, there
400.
must be a tribunal also.
Lordship,
Don't tell us.
No, Lordship, kindly.
Don't think that
Section
we are-
400.
After all, every state has a municipal corporation. Every city has a municipal corporation. And all these local bodies derive their existence from the constitution. More or less similar, maybe slightly nuances, maybe they are different.
Lordship.
You can't say that there is no provision. There must be a municipal building tribunal.
There is a municipal building tribunal
Then
for
what
the
now for-
purpose of if there is any order passed by the municipal authority.
So
if
therefore,
there is no order passed-
therefore, you are required to invoke the municipal authority under which provision? That is what we are asking you. Show us.
Lordship,
Don't say there is no provision. We will not accept it. There can't be.
Lordship, just when there is an order.
Where is the under which provision? Now tell us.
Lordship, I'm showing you. Lordship. When there is order either to demolish or not to demolish.
Under which
Section
provision?
400.
Section
400.
Yes. Give us the municipal corporation. Go and invoke the jurisdiction.
But the
Municipal corporation. Get that. We are coming back.
Item 21.
Or 21, I am praying. I am for the petition. I am praying only not today, my lord.
In this 21.
21. Not today, not today. 21 টা কোনটা স্যার?
এই তো HON'BLE.
Thursday list. আজকে নয়।
Slightly late, sir.
I appear for the appellant. My lord.
Yes,
The municipality is the appellant before you. I will not say much regarding this case, my lord. The honorable single
You are
judge,
for the municipality.
the municipality.
Which provision is there for looking into the validity of a sanction plan?
My lord, I was listening to that matter, the earlier matter, section, my lord, with regard to illegal construction. My lord, that was the Kolkata Municipal Corporation Act.
Oh, you are.
I appear for Bardhan Municipality.
So that is
Kolkata
a-
Municipal Corporation has a specific
And
act.
West Bengal Municipal.
West Bengal Municipal Act is with regard to all the.
So then the situation is akin to my parent state. There also Patna Municipal Corporation is separate and others are governed by.
Now, there are two municipal corporations which are separate: Kolkata Municipal Corporation and Howrah Municipal Corporation. And rest of the
rest come under the West
Bengal Municipal Act.
But there must be a procedure or provision.
There is a procedure. There is a tribunal. There is a building tribunal.
Tribunal is functional.
That is functional. The tribunal is functional. Municipal tribunal is there.
Yes, please. Sorry.
Is in the vicinity of New Market area, Kolkata Municipal Corporation Tribunal. Now, my lord, in this case, my lord, I will be very candid to your lordship, my lord. The honorable single judge has rightly passed an order. The writ petitioner approached this court that he has a water body. His water body is being, he's alleged that his water body is being encroached by the municipality. Now, my lord, the municipality, in fact, had gone into this water body on the basis of a complaint made by certain trustees of the temple. They use this water body also, that they are filling up the water body. Nonetheless, we should have taken steps in terms of West Bengal Inland Fisheries Act. We should have issued them notices, all this. We did not do anything. We entered into the water body, started renovating the water body. We were not encroaching. The honorable single judge reprimanded us, asked us not to encroach the water body. Well, I have nothing to say with regard to that. But the honorable single judge has saddled us with a cost of rupees 5 lakhs, my lord. I'm only on that. But there was no mens rea.
They had entirely damaged character of 200 rupees. I had shown it. Thereafter, my lord.
We had to clean it.
Not cleaning. They were doing some concrete work.
That was beautification and renovation. You know it very well.
Filling up.
Just please wait. We'll hear you. Without hearing, we will not pass any order. So where is the part where the honorable single judge deals with why he is awarding cost?
All right, I'll come to that.
That appears to be the contentious issue today.
Lord, if your lordship kindly takes, my lord, starts from inner page 12 of the impugned judgment and order. My lord kindly comes to page 13, paragraph 19. The report of the chairman dated so-and-so is considered in view of this court is contrary to the provision of section 17A, inasmuch as in the said report there is no indication as to whether the municipality has acted as per the order of the competent authority in terms of section 17A. In view of the discussions made herein above, this court has every reason to believe that the respondent authority and the police authority are practically working in a concerted way in order to deprive the writ petitioner from his valuable right as enshrined in Article 10A. The court thus considers the enshrined writ petitioner has got sufficient merit. Accordingly, same is allowed. Directs the respondent number 2 not to do any work over the writ petitioner's pond, particulars of which has been mentioned in paragraph number 1 of the writ petition, in the garb of unauthorized construction and or in the garb of beautification with immediate effect. The respondent number 4 is hereby directed to ensure that the order as passed by this court is duly complied with, either by the chairman of the respondent number 2 municipality and or by its men or agents or any person whomsoever. It is however made clear that the instructor will not prevent the competent authority to take appropriate action in terms of the provision of section 17A of the said Act of 1984 in the event the said competent authority thinks it fit and proper to take appropriate steps in accordance with the said provision in respect of the writ petitioner's pond for a just cause. Before parting with, considering the fact that respondent number 2 has practically trespassed into the pond of the writ petitioner and initiated some unauthorized work without taking any consent from the writ petitioner, this court imposes a cost of rupees 5 lakh upon the respondent number 2 municipality, which is to be paid to the writ petitioner positively within so and so.
So did you file a reply before the opposition before the writ court?
No, it was disposed of on the very first day. We had a report, we submitted a report, the police authority was there, they submitted a report. On that basis, the Honorable Single Judge disposed of the writ petition.
And where is that report?
But inadvertently, the report of both the municipality, I have checked it. My learned friend has not annexed reports of both the municipality and the police authorities. Writ petition is what
No opposition was filed.
No opposition was filed.
No opportunity also. First day the order has been.
First day order, it was passed on the very first day.
Just show us, we'll adjourn it, come with the reports.
I'll come with the reports.
Sum and substance. Requisition.
But there are two reports, sir.
Huh?
There are two
So in the writ record, it will all be there.
Yes, yes.
I will produce
Yes,
the
yes. No,
reports.
no. Yes.
We'll
No,
produce
since he is insisting that the writ record, if it is there, everything.
Grateful, man.
Yes. 5 lakh, rupees 5 lakh. Saddled. Huh.
Get
14th January. Item 22.
Your Lordship sees the last order, which is dated 17th of July. It was recorded that it is wrongly appearing under Group 4. It is a Group 3 matter. But it's a mistake on the part of the department. It is stamped as Group 9 on the top of the file. The last order passed by the Honorable Chief Justice.
Is group 3 matter. Why
Group
it is
3
here?
matter.
Why it is here? Only group 6 appeal is to come here. Or
Lordship, the appeal papers have not been served, and Lordship, it is an intra-court appeal. My Lord has jurisdiction. From 2019, my Lord has got jurisdiction.
so what is your what do you submit? It is not to be placed before this determination.
Your Lordship, it goes before the Honorable other bench having Group 3 matters. Is it 2025?
Lordship, all intra-court appeals from
All
2019.
intra-court appeals from 2019 to 25.
Your Lordship. Then Your Lordship has it.
Lordship, service has not been effected.
Appellant, Your Lordship.
So serve the
Service has not
papers.
been
Lordship,
effected.
I'll serve.
Your junior is here in court.
My Lord, he is here. He is there.
Let the
23.
Lord 23, my lord. I am the appellant, my lord. Here, my lord, incentive scheme has come. My lord, 2025, my lord. All our companies have challenged this virus of this, my lord, act. Lord, kindly make it adjournment this case, my lord.
Question is same. There is no change.
No, my lord. Change, my lord. All are, my lord, to withdraw the scheme, my lord. Actually, my lord, what has happened, my lord, 2000.
On the last day.
Yes, my lord. Yes, my lord. All our companies, my lord, company fixed, my lord. This all this matter, my lord, 15th January, my lord.
What we are asking, please.
Listen to us before you start speaking.
My lord.
On the last day, the court has recorded an order that there is a challenge to the virus.
Yes.
And therefore, since it is pending, it was adjourned.
My lord.
So situation is the same.
Same, my lord.
The learned advocate for the
Fourth February. Item 24.
By which, against an order by which my application for interim order against an order by which my application for interim order has been rejected without credit. If your order is the order, Lord, only
order is of which date?
order is of Lord 19th of September. I'm sorry, Lord November 2025. It's in the memorandum and the technical as well. Below when it goes to the order, then below I will place my
যেটা হচ্ছে কোডটা 19 তারপরে
What is triple RLF?
Raja Rammohn Roy Library Foundation. Because this is an autonomous organization set up by Ministry of Culture, Government of India in 1972.
So what is wrong with this order?
Now, Lord, in this order, Lord, before filing this application, Lord, I filed an appeal before the division bench decided over by the Honorable Acting Chief Justice. The order is here. Kindly takes up my application, stay application. The Honorable Acting Chief Justice, Lord, has specifically held in that order that this prayer, the prayer that I have made, work from home, that is to be considered by the single bench. When I filed an independent application, now I filed that application. Following that order, on 3rd of October 2025, an order of interim order was passed, giving liberty to me to work from home. That was extended. The interim order was till 17th. Now, on 3rd of October, the Honorable Single Judge, Coordinate Single Judge, directed my last friend's client to cause an inquiry on my leave reports, on my leave application. But my office premises comes under the jurisdiction of Panbazar Police Station, which is under Deputy Commissioner of Police, North. What they did, they wrote letter, 2 letters or 3 letters to Batasil Ambani Police Station, and wrote to the Deputy Commissioner of Police, Western and Central Division. So, to wrong police stations, it has been given. The main thing, kindly see page 50. The persons, before that, kindly comes to my leave letter.
No, we are not going to reopen everything. What is wrong with the order? We are asking you. We have gone through the order. The Commissioner of Police's report has been considered, and there is no material to show that there is any threat. The interim order has not been continued. Now, why the writ court should look into this? Why the writ court should look into this? We don't know why it is kept pending. It should be disposed of.
It should be
The main writ petition should be disposed of. What remains? There is nothing in the writ petition.
Kindly give me some time, a little time, Police is.
You have had enough time. So many orders. You are not. See, you are not working. That is what we are saying. You want a transfer to a particular place. Still, you are not transferred. You don't want to work. That is the impression that you are giving. And this we cannot perpetuate through a writ court. Sorry. We don't. You merely by your saying it will not become a threat. You may say every employee can come and say that he is under threat. This is not the way.
I said in my leave letter that
All has been verified. We are not going to reopen.
Kindly do not. But kindly give me some time to argue.
We are only considering non-continuance of the interim order. That is all.
Page 50 of my state petition.
Please show us what was the report submitted by the commissioner.
Commissioner
Show us where is that report.
has said
Where is the report?
Page 32
Of
the state application.
yes.
Page 65 kindly see. These I have submitted before this honorable court on 4th of September and 3rd of October when the court asked me why you have not gone to police authorities and you have not filed any FIR. I have said since I am a central government employee without informing my employer, I cannot go to police authorities. I said
Which page? Which page?
65. Police is not saying threat is not there. Police is saying there is no FIR. There is no FIR doesn't mean, Milord, there is no threat. And this I have submitted before this honorable court also.
So the admitted position is there is no FIR. Then what is to be done?
Admitted. Because Milord, I have.
And there is nothing wrong. You
The
go and
next day I received the threat. Now Milord, kindly see page 50. Kindly.
Enough.
Kindly once. Kindly see page 50.
We are not going to look into the substance of the allegation. We are only on why the interim order was not continued. It is relying on this report,
No,
nothing else.
the order of Honorable Acting Chief Justice's division bench has not been considered. But
That we will take, that we will,
no way connected with this.
that we will, that we will deal with, don't worry.
No, that is true.
That
Now,
will-
Milord, kindly see page 51. Okay, page 50.
Go and
There
show
is
it to the
no
single judge.
person to whom Milord,
We are not going to enter the merits in a matter rising out of interim order. We are not going to.
Missing your lordship.
You are, 50 is your application. Why should we look into it?
Kindly see page 50, Milord.
Sorry.
They wrote to Milord Mr. Subroto Nath to give a report. The report of Mr. Subroto Nath has not been filed. When Milord, the Mr. Subroto Nath has
Police
recommended my
report
leave
is
letter
there.
accepting that there is a threat.
Police
Let them come with the report of
Police
the
report is there. All these things you go.
threat, Milord.
Now you are repeating. Don't repeat. That you have already said. Police did not say there is no threat. Police said there is no FIR. That you have said it. Don't repeat the same. So don't repeat the same thing.
Kindly. Give me
Sorry.
2 minutes. Give me 2
We
minutes.
gather an impression that you don't want to work.
I want to work.
Unless you are given a posting of your choice. Why the writ petition is being entertained?
Supreme Court decision, it's all about policies of the
You
government.
go and, therefore you go and argue there. Who is stopping you?
I'm not entering into the merit of
Yes,
the
you go and argue there.
I'm not entering into that. In the first writ
Sorry.
petition filed in 2024, Milord, that has been discussed by the division bench.
Maybe, we
Now,
don't
Milord,
know.
kindly see page 50. Mr. Subroto Nath's report has not been filed. That is the main document on which, Milord, the report of police is to be considered. If Milord, kindly see the order of the Honorable Acting Chief Justice's division bench, following which, Milord, 2 coordinate benches have passed an interim order. That has not been discussed in this order.
All right.
Milord, my submissions have
Enough.
not been
You have got
recorded in the
enough.
order. Kindly see.
You have got enough of this continuing at that place without working. This is not the way. Now the police has come out with a report. Now what remains? Nothing remains.
No, not saying, Milord, there is no threat.
Now again you are saying that.
Very well. Very well. Milord, kindly direct. Affidavits are ready. Writ petition is ready for hearing, Milord.
Yes.
Kindly direct the learned trial judge to dispose of the writ petition next week, Milord. I am ready to order.
Why? Why should we?
Milord, without interim order, Milord, I cannot go there, Milord. Threat is there.
Don't go. You take your chance.
I can say, Milord.
Don't go.
No, I cannot take any chance, Milord. Milord, I am eager to get the writ petition.
We have seen that he has been put in a suspension also. The division bench has considered. We have seen everything what he is saying. We have seen the acting chief justice's order also. All we have seen right now. Whatever we are arguing, we have just seen. A liberty has been given that if you want to work from home, you go there. They have taken objection. That objection was left open to be. That objection.
Nicholas objection.
No, he did not. He said that objection may be raised before the single judge.
Maybe raised.
Don't misquote the judgment.
It's here.
I have seen the order.
I
The order says that the objection may be raised before the single judge.
Yes, I raised that. I
Don't say that there is a frivolous objection.
It is written.
Please read.
Am I, Milord?
Please read that division bench order.
Kindly see, Milord. Kindly see page 24.
The frivolous objection is to a withdrawal of the writ, not to the objection.
Yes. Because
Don't misquote. Therefore, we are saying don't misquote.
I am not misquoting.
You are misquoting, mister. You are misquoting, mister.
No, Milord.
Yes, you said the objection was held to be. Don't say those things. Don't say.
Letters patent.
Don't misquote. Misquoting of a court's judgment is not appreciated.
This is what they are
Please.
doing from.
This is what you have just done.
Milord,
You have just done
they are
that.
misquoting the division.
Mister, you have just done that. You have just done
They are
that.
asking me to appear before the.
Don't do that. Don't do that. Don't
Misquoting that order.
Don't go to that extent.
No,
Don't
I'm
do.
not going to that extent.
Don't do
Milord.
that.
I'm not going to.
This is not
It's all
appreciated from
about-
any
it's
counsel
all on record.
that you will misquote a judgment,
I am not.
presupposing that we have not seen. Don't do that. We have seen it.
Misquoting.
We have seen it.
Trial was objection to withdrawal of appeal, my lord, has been termed as frivolous.
Correct. Not-
Every
correct.
respondent
Only
has
to-
such a,
only
has
to the withdrawal.
to oppose any prayer.
So say that. You say that. You say that.
That is my lord,
Don't say that that objection was
I
made to.
no. Cannot say that all his objections are frivolous. That is written there. What I am on,
You are
my lord.
misquoting. That is not
My lord,
appreciated.
kindly, my lord, read petition is ready for hearing.
All right, we have heard.
I'm eager to, my lord, to get the read petition.
So go and get it disputed. You go and mention who is stopping you. You mentioned before the honorable.
It is, my lord, directed to appear in the monthly list of my lord, January 2026.
We
My lord.
don't-
I don't have much leaves to remaining, my lord.
Sorry. That's all.
Kindly, my lord, at least directed.
application এমনি চলে যায় জিজ্ঞেস করা লিখে দিই আচ্ছা
Over. What is next? Well, let's see, call from somebody.
Item number 27.
26.
26. Item number 26. One seven one nine.
But I appear for the appellant. That matter, selection of 2013. The panel was approved in 17. My lord, since my name was not in the panel, my lord, approved panel, I approached this honorable court in 17. The matter was taken up for hearing and subsequently another advertisement made to fill up the same post without cancelling the earlier selection, and somebody has been given appointment. Therefore, my lord, this complication invited by the state by appointing somebody in my place, though learned single judge is of the opinion my claim is justifiable, but nothing can be done
insofar subsequent selection has been made. My lord, I will place 2-3 judgments, my lord, in those situations. Since I have no fault, the private respondent also doesn't have any fault. In such situation, court directed the authority either to accommodate the petitioner in vacant post, or if there be no vacant post, the supernumerary post to be created. Your Lordship, kindly peruse those judgments. করে কপি দাও, এটার আর একটা কপি দাও। দেব দেব। এটা একটু দিয়ে দেব। পারফেক্ট। একটা কপি ওনাকে দাও। যেটা দিলাম সেটা কোনটা? দেখো। Para 8. এটা একটা দাও না কপি ওনাকে। ঠিক আছে। সেটা কোথায়? একটা থাকে কটা আছে? একটা তো। হ্যাঁ আর বেশ তো দিনই জাস্ট এখনো জাস্ট এইটা দিয়েছে ওইখানে রাখবে।
So you you did not succeed because of
What was the reason that you did not emerge successful?
Well, I was successful. I was in the panel. But somebody has been given, well, somebody's name has been approved. That was challenged in the court. Well, the single judge is of the opinion I was the successful candidate. I could have been given appointment, but that has not been done. That is the finding of the learned trial judge, considering my all credentials. But for the mischief done by the state, my appointment was withheld. And they have
It means you have made any personal malafide allegation against someone.
The intention is absolutely malafide.
No, we are asking you whether you have made any allegation against any specific person. That
No, the state authority, the selection committee.
so more of a nature of institutional malafide.
And well, very surprisingly, your lordship kindly peruse on order of the learned single judge while this matter was taken up. The lordship kindly peruse this.
The single judge order is not on record.
That is there. Prior to the finalize of this writ application, there was order of the single judge where it was observed. Your lordship kindly sees. Second page, it is surprising. Your lordship has got it.
কি রেকর্ডে নেই তুমি আমাকে দেখো কিটা তুমি বলছো
My lord, may I read it? It is surprising that the appointment of respondent number 9 against Bhagavanpur Sub-Center in terms of face selection list published on 17 has not been cancelled. But Suraya Khatun is said to have been given appointment as Asha Kurmi for Bhagavanpur Sub-Center. The state respondent have themselves invited the trouble by causing gross mistake while preparing the merit list. The right of respondent number 9 as per 17 face selection list unless cancelled substitute as such without cancelling her appointment, no one else could have been appointed for Bhagavanpur Sub-Center. The petitioner is also claiming to be appointed for Bhagavanpur Sub-Center. In such circumstances, Suraya Khatun is added as respondent number 10. The advocate for the state respondent shall supply the particulars of Suraya Khatun. The advocate for the petitioner shall incorporate the name of the Suraya Khatun causing insertion. Thereafter, there shall be no change in the appointment status in respect of Bhagavanpur Sub-Center and Abodh Bhagavanpur Sub-Center until disposal of the writ petition. The appointment of Suraya Khatun is at Bhagavanpur Sub-Center shall be considered once she is before this court. She was added, she was represented. This trouble was created by the state. Sorry, sir. Sorry, sir. The division major order. এটা দেখে নিন, এটা দেখে যাচ্ছি। হুম।
And the impugned order is dated
My lord, impugned order is
under appeal.
June 2022, my at page 71 of the paper book.
What is the date?
My lord, 30th June 2022. Page 71 of the paper book.
All the claimants.
yes.
You were the third impaneled candidate.
According to them, I was the top. What happened? Somebody was incorporated in the panel who is not the my lord candidate for that post. Subsequently, she declined. I am not of that post.
No, in the panel you were third.
Yes.
Later it emerged that the first person was for another not eligible because she was not a resident of this area. She was required to be considered against one of the other vacancies.
Yes.
The second was not interested.
Yes.
So under that circumstance, you have now emerged to be the only eligible candidate for that place.
Yes.
So where the first person who was found to be resident of another area, what happened to her ultimately?
She has been accommodated in that area.
To which, where
Yes,
she is a
she
resident.
applied.
And who was appointed in your area?
In my area,
because the second person was not appointed.
No.
She was not interested.
Phase selection done by the state.
When?
2020.
Fresh selection done.
Yes. Page 62.
So you did not challenge the fresh selection process.
It was brought to the notice of this court by an application.
But no steps were taken.
That is the order.
So no interim order was
I have
passed.
been asked to add her. I have to called upon to serve her. She came, she appeared. Thereafter, this order passed.
She is not at fault.
Absolutely not. I am not also not at
Yes,
fault.
both of you are not at fault.
Therefore, state is at fault. State has to accommodate me.
But see, it is not a cadre service where a supernumerary post can be created and somebody can start working.
Well, here,
Or this, there is only one ASHA worker is required, then how a second one? What she will do there?
for
Cannot be done.
1,000 population, one. There are many vacancies. There are in a
No,
block.
but this is linked to residents. You know, the scheme, it is under the scheme.
That is true.
It is linked to residents, so you cannot be selected anywhere else.
Well, in the side by side village, it can be done.
That is in a subject to certain conditions. It is not that anyone can be done that.
That is the provision. If suitable candidates are not
Not
found,
available. Therefore, we are
then
saying
entire Gram Panchayat people are eligible.
I did not say so because I have not gone into the nuances of the scheme here, but normally it is based on some conditions.
Yes, that is
It
there.
is not that anyone can be other, because it is for catering to the child health care and the female health care at the center within the village. They say it's someone local so that he can communicate better and he will know of the entire demography of that village or the concerned place. It has a very social objective for having a local resident.
Absolutely, absolutely.
Therefore, and she will be available throughout. She will not be coming and going.
24 hours.
24 hours. So supernumerary post cannot be done. Is there any other process going on? But now, since it is filled up, there it cannot be done in that.
They can come with the reports saying that if there be any vacancies in or around the village where I can be accommodated,
Cannot
or if there be any further
Such
vacancies.
direction can we give contrary to the scheme? We cannot give. Therefore, the Honorable Single Judge must have come to a conclusion that at least let the hearing official be hauled up.
That is perfectly justified. But insofar my right, which was accrued at the time of selection, that has been taken away.
No, but please try to understand what we are saying. Issue of supernumerary post will not arise here. It is not a cadre service there where one other person, if he comes, he will only help in the.
But in special circumstances, it can be done. Exceptional circumstances, it can be done.
There is only one ASHA worker.
I don't know that. At that point of time, there is one. I know the scheme.
Because there is a continuous mapping of the beneficiary area.
For 1,000 population, one. That is the scheme. There may have further vacancies in that Gram Panchayat. I don't know.
Supernumerary post will not help you. This was advertisement of 17.
No, advertisement of 13.
13.
Selection started 13, it ended in 17.
So after 12 years.
12 years, 17, I approached this Honorable Court.
No, we are saying after 12 years, the demography has not changed.
Possibly it has.
You don't have, you are a resident of that place, therefore we are asking.
The population, the vacancies, they can ascertain.
Now, if we direct that, after so many years, then others who become eligible, they will be deprived. There appears to be no way out. Under the scheme, if you can show that there is any scope for appointment in the adjacent or adjoining, let us see.
In the scheme that is there.
Let us see. You come prepared with that. We'll hear you. If there is any scope, we don't know. We will see, but we don't know for the moment. The selected candidate is here. So anyway, he is not pressing against the selected candidate. He wants to be accommodated. So if you can show from the scheme This scheme of this state, I have not had the opportunity to see till now. Probably more or less the same.
I probably that is the scheme that if nobody is found in the entire Gram Panchayat, people may apply. Therefore, in a Gram Panchayat, there may have 20-25 villages.
And these are for every village.
Every village, every Mauja.
Yes.
That is
What
the
is
count.
it called?
Mauja.
Mauja. That is the unit.
Yes,
Under the scheme, it is known as Mauja.
known as Mauja.
Is the scheme on the record?
My lord, it is in vernacular. My lord, it has to, my lord, bring the
And the overall in charges of CDPO, SDO, who is it?
video.
Huh?
No, sorry, my lord. Here, the appointment by Asha. Video.
Huh?
Video. BMOs and video. Block Medical Health Officer and video.
BDO.
Video.
And there is no authority under the scheme.
Authority is video.
Project officer, there is no project officer.
No. Under the health mission.
Where is, oh, how I can see.
This is the scheme.
See, if you want to pursue the matter for some relief, then we don't know what we will ultimately do. But we cannot consider, at least I cannot consider unless I am able to read the scheme.
That's true, my lord. That's why, my lord, English, my lord, translated copy must.
You please give, then we'll. How many pages?
My lord, scheme is of large volume, but the advertisement I find, this is of 3-4 pages.
No, advertisement will not suffice. If you
The
say,
scheme has to bring, my lord, I will.
if you say that because there is a finding that you have been wronged, a remedy should be given by giving you appointment, then such appointment cannot be given contrary to the scheme.
Absolutely.
So therefore, if there is any scope in the scheme, you may examine, you may tell us. If there is some scope, then you may come with a translation. Otherwise, we don't know what you want to do.
I will bring the scheme, entire scheme.
All right. Learned advocate for.
If
27 and 28.
For the respondent writ petitioner, my lord, please. I am for the respondent writ petitioner in this matter.
Writ petition was allowed.
Yes.
For what relief?
Yes. They filed a writ petition for a promotion to a particular post.
In which organization?
Eastern Coalfield Limited. For that post, they need to have a special qualification. Now they have acquired that special qualification. Up till this, there is no dispute on the fact. Lordship, the mode of acquisition of that particular qualification for X-ray machine, operation of X-ray machine and all, is a technical education. He, according to him, he says, he has obtained this degree from an university who had a study center here and he conducted. Now, Lordship, any technical education requires a full-time course. Now, the deliberation which I tried to impress upon the court, that see, this document clearly shows that it's admitted that he has never gone out of service. He has not taken a long leave. Of course, I granted him leave, that you take leave and do it. I don't mind. He was working in my hospital. He is in my organization. He was doing as a support staff to the same job. But he has completed this. We cannot recognize because we cannot take risks on the patient. My organization has its own hospital as well. So whenever you are doing imaging something, so we cannot take risks. We are contesting this matter. I don't mind. My one employee will take another promotion or another esgatia. I don't mind really. But my problem is if I really take him to that post, Lordship, it may cause a danger for my employee only who will go to that hospital. This is the crux of the matter. Now, Lordship, they say that they have obtained this decree from a university. That university itself, Pariyar University, is in the south.
Parihar.
Pariyatu. Did I pronounce correctly?
Pariyar.
Can you spell it, please, or can?
At Salem, at Kerala.
Kerala.
Yes.
And he's posted here.
Yes.
Yeah.
Tamil Nadu, my lord.
Huh?
And is Tamil Nadu. Salem is at Tamil Nadu, and my lord, the study center is at here.
Oh, so it's a distance course having a center here, according to you.
Yes. Now we could not trace out the center at all.
Where is the center?
At Asansol. This is my second round of writ application. Initially, I succeeded. The trial court, my lord, returned with the findings that the petitioners having the, my lord, requisite qualification. That has not been questioned by them. Now they are raising the question which has been attained, my lord, finality. Kindly read the entire order, my lord, of the trial court. Your lords will find.
Of course, eventually I will place both the two orders on my finding, because if the first round of litigation you would have succeeded, then I would have faced contempt, not the second round of litigation. First round of litigation says that he has done this. Kindly look into it whether it is correctly done or not. He has acquired it. First round is give me this.
What was the extent of liberty in the first writ order? Let us see.
If your lordship kindly takes the first page 52. Lordship, I am looking into matter of Gautam Kumar Lai. Paper book the Gautam Kumar Lai.
We have it. Page 52.
Page 52. Lordship, if your lordship kindly turn to page 54, bottom. Last but one paragraph. We, however, submit a decision will be taken on the application of the petitioner and the result will be made known to him. It is within the meaning of the means of the respondent to ascertain whether Pariyar, from where the university has obtained his diploma, is a recognized university. So far as the contention in the affidavit regarding the diploma obtained in radio imaging, not qualifying the petitioner as a lab technician, As because the petitioner is presently working as a ward boy in the concern, it is argumentative avowment which might be substantiated as a reason, if possible, on basis to be stated in the order disposing of the application of the petitioner one way or other. In view of the submission made on behalf of the respondent number 5 as submitted by Mr. Banerjee to be appropriate authority is directed to consider the matter and take a decision on the claim of the petitioner to be appointed or promoted to the said post as posing the requisite qualification, having successfully participated in the prescribed selection. The said respondent will deal with the matter and dispose of the same within the period of 4 weeks, such and such and such. Now, Lordship, if your Lordship kindly see, now Lordship kindly turn to page 88. Now I am supposed to pass a reason order. Then I passed a reason order. Lordship, we tried to reach the university. University did not. Now, Lordship, why I have lost the case? Let me confess very categorically. So far as the existence of the university is concerned, it is there.
That is what is crossing our mind also. See, you lay down a qualification. That qualification is certified. Then is it open to you to see how many days of classes he has done, how he has done it? And
Lordship, I tell you, Lordship.
If your qualification that you require is produced, can it be left to a scrutiny by the employer?
Went to the court a few days back. I will rely. Lordship, there was a provision of becoming engineer. Diploma engineers used to become a full engineer by a course called AMIE, which was organized by the Engineer Institute, and it was not a full-time course. It was a course to the extent of the way of distance mode. Now, Lordship, whenever there is a distance mode, that particular engineering system has been discontinued by the Delhi High Court and then gone to the Supreme Court. Supreme Court said, no, it is not possible. Lordship, a person without having a law degree can be a bachelor of law, but then enrollment is not possible.
The question which arises in your case is when an employer lays down a qualification, an employee comes with a qualification, is it open for him to now look into how many days of classes he has done, how he has done it?
No, I'm not looking that.
Either you have a qualification or you don't. If he doesn't have, then he's out. If he has it, then can you go into this scrutiny?
No, I cannot. I should not.
Then
I am only like
it is for the policy makers to decide, or the court may say that distance education will not suffice having regard to the nature of course study and all. That is a different thing. Can the employer start looking into this in every
what I can do
process?
Is, like suppose I have done my master's in law in a distance. He has done in way of a regular course. Now who will get admission in PhD? For PhD, only regular category, both are having the same qualification.
Therefore, we are saying whatever is the advertisement for promotion, that will prevail. If it does not cast a distinction between the two modes of acquisition, then where is the question? Then it becomes an arbitrary exercise. You can do whatever you want.
Lordship, I would bow down before your Lordship, but my request will be to the bench to look into the. Sorry, I'm sorry. Lordship.